Welcome to this, the latest in our series of Talking IP sessions. We're starting much earlier today because the topic of today's conversation is IP protection in China, and we're very lucky to be joined by a guest from China. As you'll have heard from the voice at the beginning before I started speaking, this session is being recorded. So if anybody does want to catch up on anything that's been said later, it will be available on our website soon after the end of the session. The session today is going to be chaired by our head of IP litigation, Claudia O'Brien, who is also deputy head of our China desk and spent a couple of years in Hong Kong as a lawyer before coming back to the UK. So is something of an expert on China herself. Claire is going to be joined by Lindesay Low, who's the deputy director of legal affairs at the Scotch Whisky Association. Good morning, Lindesay. Adam Branscombe, who's a UK and European patent attorney at Domino Printing Sciences. Morning, Adam. And finally by Claudia Yun, who's an IP partner at Fangda Partners, our Chinese best friends. During the session, there are going to be a couple of polls. It would be really helpful if you did participate in the polls. It's interesting to get a feel for what people think on these questions when we put them in. If you have any questions, and there will be a question and answer session at the end. If you put the questions in the chat box at the bottom, then my colleague Isabel here will collate those and ask questions of the panel at the end. And with that, my job as your host is done, and I will hand over to Claire for the discussion. Thank you. Over to you, Claire.
Thanks, Mark, and good morning, everybody, and good morning to the panel, especially. I'm going to start, if I may, talking to Lindesay about the Scotch Whisky Association, and then I'll move on to Adam, and then Claudia, and then, as Mark said, we'll have questions at the end. So, Lindesay, if I can start with you. Good morning.
Morning, Claire.
Morning. Please, can you tell us about the Scotch Whisky Association and its aims, and what your role is there?
Well, the Scotch Whisky Association is the trade association for the Scotch whisky industry. We started round about 1912, and our mission is to create the best possible business environment for Scotch whisky around the world. Legal protection of the geographical indication Scotch whisky is very important in that, and I'm part of the legal team. We're a team of 6. Whose job it is to make sure people don't make fake Scotch whisky.
Okay, thanks. And is Scotch whisky protected as a geographical indication and a collective mark? And if so, what does that mean in practice?
Well, Scotch whisky is protected in just about every country in the world. One of the things we're very proud of is that Scotch whisky is not generic in any country, and that's unlike some other geographical indications. So you can't get Scotch whisky made locally. But in China, we've got 2 forms of protection, as you say. First of all, we've got a collective trademark, which means that it's a mark that can only be used by companies that make Scotch whisky. And secondly, it's protected as a geographical indication, which means it has to be made in Scotland in accordance with a very strict set of rules. For practical purposes, it doesn't make a huge amount of difference, but it's very much a belt and braces approach. The 2 forms of protection were available, so we took advantage of both.
Mm. And does your mark have elevated status because it's something that you drink as opposed to, say, luxury goods or other items like that? Do you think it has an extra added status because it is something that you drink?
Well, I think in practical terms, particularly when we're looking at administrative enforcement, that's when we file a complaint with the authorities, it does get taken more seriously, along with other ingestibles, so pharmaceuticals or even cosmetics, things that you put on your skin, simply because it can cause you serious harm, not just economic harm, but actual physical harm if you end up with a fake product.
Yes. And as well as having a geographical indication and collective mark, what other steps do you take to protect your mark in China?
Well, the first thing is gathering intelligence. We have quite a complex trademark watching service because we're not only looking for infringement of our product itself, but we're also looking for the use of Scottish words and symbols, things like Glen or Highland or the Loch Ness Monster, as it's a sort of early warning system of people that might be trying to make a product that looks like Scotch whisky. We're also take part in education. We've done a lot of outreach in the media to the consumers, also to the enforcement authorities, letting them know what it is. And of course, where we do find people making fake Scotch whisky or products that look like Scotch whisky, we're opposing their trademarks. We are taking various forms of legal and administrative action to try and stop them.
Yes, it sounds pretty comprehensive what you're doing. Can you tell us about any legal action you've taken? I believe you've taken a number of cases in China, but particularly the one about the labelling of the caps of bottles of whisky as Scotch whisky.
Yes, well, that was a case we took a few years ago in Anhui province in southwest China. And it was slightly unusual because it started off as an administrative action that was a complaint against a company that was manufacturing what we call dry goods, which are bottles and caps and labels. And those featured the words Scotch whisky. So we were able to follow up on that. The authorities recognized we had well-known mark status. So even though our mark was not registered for those goods, we were allowed to enforce it. And we followed up both with criminal action against the principals of the company involved, but also civil action against the company itself, leading to a fine and seizure. And it was quite helpful because the caps and labels related to brands belonging to our members, which were not protected in China. We believe that these products were going to be shipped to Myanmar for use on counterfeit. So our members couldn't take direct action, but because we had the rights to the Scotch whisky mark or geographical indication, we were able to intervene. So that stopped really two problems: misuse of the GI and infringement of the proprietary brands belonging to two of our smaller members.
And do you get involved? It's interesting that in that case they split production between different locations, possibly probably to reduce the chance of being caught. But do you get involved in quite a lot of cross-border cases, or was that was that just a particular one because of where the caps were made?
It was quite unusual. I mean, what we tend to find for fake Scotch whisky, it tends to be manufactured in the place that it is. Manufactured in the place that it's consumed.
Yeah.
And I think that's largely because a lot of the companies involved in that particular type of conduct are established wine companies or spirits companies who just have an illegal sideline. When you get into brand counterfeiting, you get into different territory. And I think they have very sophisticated supply chains designed to keep inventory to a minimum. So any penalties will be reduced and also make them harder to catch. So that was something that was a little bit of an exception for us. Most of the fake Scotch we find tends to be made up in East China and sold in southern China or the big cities, Shanghai and Beijing.
Yeah, it sounded like that case was you got a good outcome with the remedies that you needed, injunction, damages and costs. But did you have any concerns about filing a lawsuit in China? And if so, what were they?
We find that China has its challenges. I mean, we take cases all over the world, and I would say China is by no means the most challenging country to take cases in. For us, there's quite often a lot of practical difficulties because there's a very high reliance on documentary evidence, which has to be legalized and notarized. And I was playing around with ribbons the other day because I was having to tie a letter together with pink ribbon, so it would be accepted actually by the Trademark Office. So that's always something we've got to get right. I think also with that case, because it was slightly unusual, you sometimes have to persuade, particularly in the criminal forum, that the prosecutor and indeed the court should take the case. I think, when things are unusual, you have to be very persuasive just to get people to take a step. But having said that, we found that the court system works well. We find that the rule of law is upheld, protecting foreign IP rights, and we generally get what we want. Some say the penalties are not high enough. I would say perhaps the fines for a determined counterfeiter might be seen as a cost of business, but in our experience, they're reasonable and sufficient to disrupt and dissuade. So yeah, overall, I would say 7 out of 10.
That's good. That's good. You mentioned about evidence needing to be notarized and legalized. I'm going to ask Claudia about that later on as to why that is the case. But is that difficult to do? Is it time consuming? Is it expensive? Would it put you off? Well, clearly it didn't put you off, but how much of an issue is it?
I'd say it's a nuisance, and I'd say my tip is, make absolutely sure you understand what's involved. I mean, the most annoying thing are documents going backwards and forwards to China because, somebody hasn't put the correct seal on it. So I think it just takes a bit of preparation. And if you've got the proper advice and you take care, it's certainly doable.
Yes. And do you have any practical tips for litigating effectively in China? We've talked about the requirements in terms of evidence and the need to persuade the authorities to take on slightly unusual cases. But from a practical, on the ground point of view, do you have any tips?
Well, I think perhaps not so much in the actual court litigation, but when you're dealing with enforcement authorities, I think visiting China, familiarizing yourself with the market, meeting the organizations involved goes a long way. It enables you to get a realistic understanding of what can be achieved. It's also a great mark of respect. If you're going to some perhaps quite rural place or a second-tier city, and you come all the way from the UK to explain what your concerns are, you get a lot of recognition for that. So that's something that I'd certainly advocate. I'd also say, and this is probably trite and applies everywhere, but don't forget to register your rights, because we've had a lot of people coming to us saying, oh, it's terrible, I'm getting ripped off in China. And you say, well, what have you done? And people have to realize there is a sophisticated IP system in China, and you can avail yourself of it. And you should do so, because if you don't, then understandably the Chinese don't have a great deal of sympathy. And then lastly, what I'd say is do what you can according to your budget. We sometimes get people saying, well, you're a big organization, you've got big members, you've got lots of money. But I would say that even registering a single mark and enforcing it puts you head and shoulders above a lot of other organizations. It will displace counterfeiters. It will make people know that you are serious about protecting your brand. So you don't have to do everything, but do what you can, and a little goes a long way.
I think that's very good advice, because I think one of the temptations is to think the scale of the problem is so big that you're overwhelmed by it and decide to do nothing at all. But I think the idea about getting a budget and do what you can is a really good tip. We've talked a little bit about the different enforcement routes. We've talked about local enforcement and also a civil action, and then you've also touched on criminal action. What in your view is the benefit of taking local administrative action in China as opposed to going straight to court? And how do you choose between the different things?
Well, administrative action is certainly, it's very good because it is quick. It's comparatively cheap. You really only have your own lawyers and investigation fees to pay, and it's excellent for disruption. So when we first started working in China, and there were many different companies making fake Scotch whisky, using the administrative route was a great way of getting the situation under control. And there were a lot of companies that were really, for want of a word, just chancers. And as soon as they got a warning or maybe a small penalty from the local enforcement authority, they stopped. So that allowed us to sort of focus in on the more serious frauds where we could take civil cases. The other thing it's really useful for is gathering information. because a raid will take place. You will find out, you will get access to documents, you will get access to, in our case, liquid, which can be tested, and that can form the basis of evidence for a civil case. So it's always worth doing that. So yeah, it certainly has its place.
Yes, and just to round up with my questions, although I would encourage people to put questions in the chat for you, Lindesay, and we will deal with them later on. I understand that you have been taking action in China for over a number of years. I don't know how many years, perhaps you can let us know, but also when did you first start seeing results? Was it immediate? Was it mid-term, long-term? When can you expect to see some results? It sounds at the moment like you have a good program for managing infringements, but I was just wondering how long it took you to get there.
Well, I think our first case in China started in 2004, and we see a pattern globally in that it will start off by brand counterfeiting. So the big Scotch brands were being infringed for quite a few years before that, and then people started saying, this Scotch whiskey has got some value, or maybe realize, well, we can't make direct copies of these marks anymore. So we became involved then, and as far as taking individual organizations out of the game, that was almost immediate. We started a lot. Our activity, however, probably by about 2008, 2009, we were really seeing the level of Scotch whisky counterfeiting dropping significantly, and down to the level where it is today, and not dissimilar to what we see in other markets in Europe and other parts of the world.
Yeah, that's really encouraging. Well, thank you so much, Lindesay, for those useful insights. Do stay on for any questions coming on towards the end from the audience. But thank you again. And now I would like to ask Adam about his experiences in China in relation to domino printing. Adam, morning, Adam. Can you tell us a little about Domino, your role there and your activities in relation to China?
Yep, sure. Domino is sells a wide range of industrial inkjet printers. It's about a 25-year-old business, and these are the sort of printers that you would use on a production line, say if you need to put date codes onto products going down that production line. But they also go up to really quite large printers that would print sheets of labels that are going to go onto products, or cardboard box blanks if you want to customize cardboard boxes for a short print run, for example. Since 2015, we've been a wholly owned subsidiary of Brother Industries Limited. I'm Domino's patent attorney and responsible for protecting or getting patent protection for Domino's products, and also making sure that Domino doesn't infringe anybody else's patents. We have a reasonable number of Chinese patents in our patent portfolio of various sorts, predominantly invention patents, which are what most people would think of by a patent. We do have some design patents, so patents that protect the appearance of parts or pieces that go into the printers. And we have a Chinese business which is keen on using utility patents, which are for sort of less significant inventions, where perhaps a normal patent, they wouldn't be inventive enough for that, but they pass that threshold. It's a lower threshold for these utility patents.
And do you do double filing in relation to that? Do you file both for utility models and the invention? We
haven't done that yet. It's certainly something that we've considered, but not something we've tried yet. Simply because it seems to be a bit of a split that the things that lend themselves to utility patent filings tend to come out of the Chinese business, and they're for fairly short-term projects. The ones that the other inventions that come from around the rest of the business that we want to patent in China are sort of longer term than that. But yeah, it's something we've considered.
Yeah.
I guess though, my main involvement with China is to do with its counterfeit trade.
Yes.
And
Yes.
dealing with that.
And what do you do to protect you've talked about the rights that you register, but what other actions do you take to protect your IP in China?
We have a number of trademark registrations, as well as the patent rights, and we have a watching service which is always looking out and alerting us if somebody tries to register something that's similar to one of our marks. We have a sort of informal watching service as well. I mean, a lot of our sales guys will keeping an eye out on things like Alibaba and will let us know when they see pirate inks being offered. And in the last, I would say, year in particular, we've seen our distributors coming to us because they've been approached by pirate ink makers saying, "Yeah, do you want to save? Can we come to an agreement?" And it's a little bit odd. It seems to be. I can't imagine there's any link between Chinese bank holidays and UK ones, but it seems like after a UK bank holiday, there's a raft of these reports of approaches from Chinese pirate ink makers that come in every bank holiday.
Okay.
I haven't found the link yet. May just be very
Okay.
good intelligence. I think people are likely to look at it at that date.
Okay. So it seems like you've got a number of methods to look out for your rights, and a number of people on the ground and eyes and ears looking to inform you when infringements do come to light. But before I launch the audience poll, actually, I'd like to ask you, and without giving away too many secrets, do you have any technical mechanisms embedded within your products to identify or protect them as originals? And has this helped to control infringement?
We do. Without wanting either to give away secrets or get too technical, our printers can accept a number of different inks. So depending on whether your production line, say, is printing on glass bottles or glass jars or tin cans, for example, you would use different inks for that. And if you mix those inks in the printer, there's a chance that you'll damage the thing. So the ink containers that go into the printers all have RFID tags on them, which tell the printer what sort of ink has just been put into it. And the printer will then check whether that ink is compatible with the last one that was in there, or whether it's going to damage the printer and it will stop it from going into the printer. So that's primarily to avoid a load of avoidable service calls. But it does have the effect that if somebody wants to produce a pirate ink, then unless they get the details on that RFID tag correct, then there's a good chance that the printer will reject the ink because it thinks it's one that's going to be incompatible with the last ink that was in there.
Yeah, interesting.
So that has helped. Yeah. It means they need to buy one of each of the different types of ink that they want to sell to get the details off that.
Yeah. Okay. I think it's a good juncture then to launch an audience poll just on that issue. The question is, do you use technical measures to protect your IP? And if yes, how effective are they in combating infringement?
In our experience, I would say that it's a bit of a binary question, that one. They're extremely effective until they're not. Okay. So about 30% of the audience, and I know we've got a very diverse audience today, do use technical measures to protect their IP. That's really interesting, and I'd love to know what they are. We have, as I mentioned, got such a diverse audience in all different industry sectors. So I'd be really interested to know what those are. And of those that do, there is some people think they're very effective and others don't know, but it's interesting to see that is at least one way to try and combat infringement. I know, Adam, you said it was to stop the service calls as well, so it seems to serve a number of purposes.
Okay, that's interesting. Okay, can I ask you then, Adam, that I know in 2018, Domino brought a successful claim in China, which was one of the landmark cases of that year. Can you tell us a little about it and why it was unusual?
Sure. Well, I'll start with why it was unusual, which is that it involved manufacture of printers, and the vast majority of the infringements that we see are people selling pirate inks, because obviously, no disrespect to Lindesay, but mixing a colorant into a bit of alcohol is a lot easier than building printers. So the yeah, there were two things that the infringer was doing. They were getting hold of older model Domino printers and stripping out the ink system of those and reselling them. And I think the reason that they were doing that was that we had some patent protection at the time on the ink system, which meant that if they were selling the cartridges that went into the printer with pirate ink in them, then that would be an infringement of the patent protection. So that's why they were modifying the ink system. And you might wonder why we were worried about a second-hand market for these printers, but they actually last for a very long time. And at that time, we were releasing a new generation of printer. So we anticipated quite a lot of second-hand ones getting onto the market. And in normal circumstances, we'd have expected to be providing the inks for those printers for a good while longer. So that was why we're keen to stop that activity. The other one was that this company were getting hold of main boards for Domino printers. So this is a thing a bit like the motherboard in your laptop, and they were building a printer around that. So the printers with the modified ink system had a Domino badge on the case. That was clearly a Domino printer. The ones built around the main board were not, but because it was a Domino main board with all the Domino firmware on it, when you turn the printer on, it would come up with all the Domino logo.
Okay. So
yeah, we went after them for both trademark infringement and unfair competition on the basis of those printers.
Was the logo only visible after you'd bought the printer and turned it on? Okay,
in the second case, yes, it was.
In the second example, okay, yeah. Right. And so what happened at first instance?
It was a resounding success. They were found to have infringed the Domino trademark registrations, and it was also that the sales of those printers were found to be unfair competition, which for those in the audience that aren't familiar with it, is a bit like UK passing off. So infringement of an unregistered mark, but one where you have a reputation in that mark.
Okay, and I understand the case was appealed. What was the outcome in relation to the appeal?
It was appealed, and I think in hindsight that was probably inevitable, because there were the company faced both criminal and civil penalties. So I think it was almost, we were almost victims of our success there, that they were going to appeal that because they were looking at criminal penalties.
Okay.
So on appeal, the trademark infringement was the registered trademark infringement finding was overturned on a technicality, and on the unfair competition point, the modified printers, they were held to be that was upheld, and the ones built around just a Domino main board, the unfair competition finding was overturned for those printers. Right.
Okay. And you talked about the remedies. Did you feel the remedies? I assume you obtained an injunction and damages and costs and all the rest of it. Did you feel they were effective?
They certainly were, and yeah, as I've mentioned before, you could even argue they were too effective. I mean, the criminal findings stopped them in their tracks, but it sort of guaranteed that they were going to have another go, at least, an appeal against that finding.
Yes. And were there any challenges that you encountered in bringing the case?
Only the usual of which Lindsay's mentioned, of the high sort of evidentiary sort of procedures that you have to go along with. Okay.
And why was this case regarded as such a landmark case? I know it got quite a lot of publicity at the time.
Yes, well, I think it showed a high degree of sophistication in the Chinese IP system. We can probably just disregard the trademark side of it. That was a technicality, really. But the unfair competition point, the defendant raised a defence of exhaustion of rights, which is this idea that if you have an IP right that protects a product and you put that product on the market, then once you've put it on the market, that right is considered to be exhausted, and you can't have another bite at the cherry, if you like, and keep on asserting that right against subsequent owners of the product. So they tried to use that defence, saying that because this was a second-hand printer, it's that those rights in the trademarks and the Domino brand were exhausted. Mm. And the way the court looked at it was to say that for the printers that had been just modified but still carried the Domino trademark, those that was actually still taking advantage of unfair advantage of Domino's brand, because a person buying the second-hand printer would know it's a second-hand printer, but they'd expect it's a Domino one. And if you've changed the guts of that, then the consumer is going to be deceived there.
Yeah.
The other one where it was just a printer built around the main board was more difficult, and you'd, I think, spotted the problem already earlier on, which was that it was only once the printer was started up that it displayed the Domino branding.
Yeah.
And so they successfully argued there, and probably reasonably, that there could be no confusion of the purchaser of the second-hand or of the printer there, because they didn't become aware that it was had anything to do with Domino until they'd bought it and taken it home and powered it up.
I see. Well, I'm glad that the appeal court did uphold at least one of the cases, and it sounds like you did get the remedies you were seeking. So that's good news. And just before, I'd like to bring in Claudia soon, but just before we do, in a nutshell, can you explain to me what your top tip is for optimizing IP protection in China?
Yes, sure. I think it's probably not necessary to rely on IP. We've had some success in the past. The inks that we sell contain solvents, and so you need to have a license in order to sell those. And some of these pirates don't do that, and so they're committing an offence by selling these products without a license. So actually, if you can get the Chinese state onto them and do your dirty work for you, that's even better than going to court, and can be quicker. It can even help in the case of people like Alibaba, who desperately do not want to be seen to be facilitating sales of unlicensed products like that.
Okay, so it's a different way of coming at the problem.
Yeah.
Adam, that was really interesting to hear about your experiences in China. Thank you. Thanks very much. And do stay on for questions at the end, and I encourage the audience to send some through. But
sure.
Thank you very much. And I'd now like to bring in Claudia. Hi, Claudia. Thank you for being so patient. So you've heard the experiences of Lindsay and Adam, and I would like to start by asking you, how important is it to register your IP in China, and when should businesses do this?
Right, thank you, Claire, and good morning, everyone. I really enjoy the conversation with Lindesay and Adam. It's really helpful to understand the insights from the in-house perspective on protecting their IP rights in China. As for the question in relation to the timing for filing the IP rights, I would say for trademarks and patents, I will encourage foreign companies to do the registration as soon as possible, as early as possible, and even before they are considering entering into the Chinese market. For trademark, because we adopt the first to file policy instead of first to use, so this unfortunately gives exporters the incentive to preemptively register the brands of foreign companies. So if you don't register a trademark before they do, you may have to invest a lot more of costs and efforts to get rid of the exporters' trademarks before you can protect your own trademark.
Okay.
And for patents, because there will be priority period. So I will encourage foreign companies to file their patents before the end of the priority period, because if you don't do so, then you might have your protection in the foreign jurisdictions, but in China, it will be considered as a technology in public domain, and every one of your competitors will be able to use your technology in China if you don't have the family patent filed in China. And this does not only cause the problem in relation to your protection of your technology, but it can affect your future business opportunity of investing in China. I've seen a lot of companies who wanted to do some in-kind contribution to a JV by investing their technologies into the JV, or they just do some licensing work to the Chinese party to gain some royalties. But they were not able to do so because they have no family patent filed in China. So this really affects their future business plan if they don't do the filing in time. So those are the advices for trademark and patent filings in China. For copyright, because like in other jurisdictions, the copyright is generated once the work is created, so there's no need for registration. But still, if you want to have your copyright better protected, you can have it recorded with the China Copyright Protection Center or other corresponding authorities. You will be able to produce evidence if you want to bring some action against the copyright infringers.
And is there a cost to that recordal of copyright? How much does it cost?
Yeah, just hundreds of RMBs. That would be very cheap. Yeah.
Okay, and it's worth doing. Would you recommend that?
Yes, I do recommend that, but just be careful about what kind of copyrights you can register, because for some industrial designs, unlike the design rights in the UK, industrial designs are usually protected as design patent in China. So you will have to file for design patent to the Intellectual Property Office instead of the Copyright Protection Center. So basically, if you are trying to protect the design of some industrial creations and artistic work of industrial outlook of your product, then you might consider about filing a design patent instead of registering as copyright.
Okay. And Lindesay talked about Scotch whisky being a geographical indication in China. How easy or difficult is it to obtain this status? And what about well-known mark status? I understand that's something different. Again, how easy is it to achieve, and what additional protection does it afford?
Right, I think it's not really easy to get the geographical indication registered in China, especially for foreign parties. But we have seen the number is growing in recent years. According to the 2020 national report issued by our IP office, they have already approved 765 geographical indications in 2020. And at the end of the same year, the total number of the GIs in China has reached over 6,000, which is over 14% increase compared to the end of 2019. So you can see the number is rising. But for a foreign applicant, if you want to obtain a geographical indication registration in China, it's really important that you can provide a proof on the recognition of the geographical indication in the relevant jurisdiction in your original country. That's very important. Because the Trademark Office will require you to provide evidence like the approval document issued by the local government of the industry, and also the certification proving that the GI is protected in its original country, under your name. And also you might need to produce qualification document proving that you are able to supervise the specific quality of the products bearing this GI. So those are the things that you might need to produce. But once you have the documents ready, then I would say that the procedure will be quite smooth and easy, and you don't need to worry about the whole procedure thing.
Okay, so we thank you very much for that. It's very interesting. We've talked quite a lot about trademark rights in China, and you've touched also in your first answer about the different forms of patent protection. But I think it is a bit different to the UK, so I'd quite like to ask you a little bit more about that. So you have different types of patents. You mentioned invention patents, design patents, and then you have utility models. Is that right? And Adam also talked about utility models, and we touched on the point about, well, perhaps first of all, you could tell us what utility models are and how long they last for. And I also touched on with Adam the point about perhaps double filing, both utility models and invention patents. Do you have any comments on that?
Yes, we have three types of patents, as you have mentioned, the invention patent, utility model, and design patent. And three of them have different protection terms. For invention, you have 20 years. The utility model, you only have 10 years. But for design patents, you have 15 years of protection, or from the application day. For invention patent, it protects a technical solution relating to products and process or the combination of them. For utility models, you usually protect the shape and structure or a combination of the shape and structure of the product. For design patent, it usually will protect the shape, pattern, and the outlook and colors of the product. So for the same technology in relation to the same product, if it's related to the shape and structure of the product, you can do the double filing for both utility model and invention patent. Because for utility model and design patent, you don't need to go through the substantive examination for the patent being granted. So it's pretty fast to go through the whole procedure before you get the patent granted. For utility model, it maybe just take about 6 months before the patent is granted. So if you do the double filing, you can get the utility model granted pretty quick. And then during the protection period of utility model, the invention patent may pass the substantive examination. And then the IP office will inform you that your invention patent is about to be granted. Do you want to waive and give up your utility model? And if you agree to give up your utility model, then your invention patent will be protected. And you have longer protection period for your technology as an invention patent.
Yeah.
So that's how we do for the double filing of the two types of patents.
It's quite an interesting idea, I think. Yeah. And perhaps one that businesses do use in China to protect themselves in the short term, and then without having to go through the examination procedure before they get their invention patent. Okay, right. And just moving to another point actually touched on by both Lindesay and Adam when they were talking about their experiences in China. They talk about the evidence needing to be, for cases needing to be notarized and legalized. Can you explain why you need to do that in China? Because it certainly seems a bit of a hurdle to overcome.
I know, yeah, I fully understand the pains because we always help our clients to do that kind of notarization and legalization work. The whole purpose of notarization and legalization is to confirm the authenticity and validity of the evidence, because it's generated from outside of China. And usually, for example, for a contract, it's usually signed by individuals. And because the Chinese government, especially courts, they would not be able to verify whether the signature is authentic or not. It will help them to be able to recognize this kind of evidence if it's notarized at the local notary public office and then legalized through the embassies. So that's kind of work that they do to confirm the authenticity and validity of the documents that you present before the court. But actually, in recent years, the evidence rules have changed. And right now, according to the new judicial interpretation in relation to the evidence that you're going to use in civil procedures, you don't really need to notarize and legalize everything. only those documents issued by the government or organization based on their authority, or only for the evidence that would be helpful to prove the identity or relationship of the parties, would need to be notarized and legalized. For other types of evidence, if you have the evidence train that is solid enough to prove that the document that you present to the court is authentic, then you don't need to notarize and legalize the document.
Okay, so it will lead to a bit of a cost saving. So the rules are changing. That's interesting to know.
Yeah.
And also I'd like to go back to another point that we talked about with Adam, was the subject of the first poll. So he talked about technical measures within the products themselves to deter service calls and infringement. So can you tell me, are there anti-circumvention laws in China?
We don't really have the law called anti-circumvention law in China, but for copyright protection, especially the protection on computer software, we have the anti-circumvention provision, which says that if anyone is trying to avoid or destroy the technical measures applied to protect the software, then this kind of action will be considered as infringing and will be considered as copyright infringement. So even if you don't copy anything, so long as you apply this kind of technology to deliberately destroy the technical measure used by the right holder to protect its software, then this kind of action will be considered as infringing. And also for trade secret protection, according to the new judicial interpretation, if you illegally obtain someone else's trade secret, and then you develop your technology, maybe something to design around according to the technical information you obtain through stealing others' trade secret, then this kind of activities will also be considered as trade secret infringement. So that kind of regulations, just a few provisions in different laws and judicial interpretation in relation to the anti-circumvention protection on the IPs.
Okay, that's really interesting, Claudia. Thank you very much. I can see quite a few questions have come into the chat function, but before we go to those, I'd just like to launch our second poll, if I may. And thank you very much, Claudia, for your insights and helpful information. So, having heard the experience of our speakers, do you feel more or less confident about bringing legal action in China, or about the same? So that's great. It sounds like 71% people feel more confident about bringing legal action in China. About none feel less confident, which is good, and about 30% feel the same. So it's good that we are getting a positive message out there in terms of what can be achieved in China and how to go about doing it. So thank you all very much to the Lindesay, Adam and Claudia for answering all my questions. I'd like to hand over now to Isabel in relation to any questions we've received through the chat function.
Hi everyone, we've had some great questions coming in. So to begin with, we're asked, is it useful to register the mark nationally as well as internationally? And if it's registered nationally, do we need a translation or transliteration of the mark to be registered? So I guess, Lindesay, do you have comments on that question?
Yes, well, with Scotch whisky, we really have to register nationally in every jurisdiction because of the nature. So I'll let someone else perhaps deal with that. But what I would say about the transliteration is, yes, we have registered the Chinese characters for Scotch whisky. I think it's a wise thing to do. China's a little bit more relaxed about use. So in other countries, it's been a challenge if we're not actually using it, but in China, it seems to be fine. So we have that. We've made use of it a few times, and I certainly think it's worth the small investment required.
Adam, do you have thoughts on registering marks nationally and using transliterations?
Nothing I suspect that will be terribly helpful, I'm afraid. We do register very widely. So I think pretty much all countries around the world we have at least registered Domino in. And I know that we do use the transliteration for our Chinese registrations, but I've not been that closely involved with it.
Claudia, what are your thoughts on that?
Yeah, I would think that it's very important to register the trademark both internationally and nationally, especially for Chinese market. I would advise our foreign companies to take a look at the Chinese market and check on how the your potential consumers would call you in the Chinese name. That is very important. Like in the Michael Jordan case, actually, the squatter registered its Chinese name, the Chinese transliteration name as the trademark, and then they use it for almost 20 years, and they became so well known that it took us several years to take them down. So basically, I think it's very important to understand how the Chinese consumer will call you in the Chinese name, and then you register that Chinese name as a trademark in China so that your mark will be protected. I think Claire would have the same story for Jaguar and Land Rover, right?
Yes, I think I agree with you what you say, that it's important to do both.
Yeah, there's a related question, which perhaps, Claudia, you can tackle. And I think you've mentioned something about this before. At what point do you start registering your rights in China? And the questioner asks whether it's when you're about to start manufacturing there or sooner. And I think from what you said before, Claudia, it's sort of as early as possible.
Yes, and we've seen quite a lot of examples where a lot of foreign companies, they have not started entering into the Chinese market, but they have become reputable in foreign jurisdictions. And then the trademark squatters in China would register both the English name or the foreign names and their Chinese translation and Chinese transliteration names in China, and so that they can just wait for the foreign companies to enter into the China and do their business here. And also, we have seen quite a lot of companies, they only do OEM manufacturing in China, and all of the products are exported outside of China. And for those companies, they at first they didn't think it necessary to do the registration in China. But this is very risky because if the squatters have registered your trademark while you're doing the manufacturing in China, even if you have all the products exported outside of China, the squatters might just threaten you with IP infringement litigation and say that you are infringing their trademark rights and ask you for a large sum of damage. So that's quite risky work. So I would say if you may just think about the possibility of entering into China someday, or have your products being manufactured in China someday, then you would have to start thinking about registering your trademark in China.
Thank you. There's a question here. Oh, Lindesay, did you have a point to add there?
Just very quickly to say, and it may surprise some, always register your marks yourself. We have seen a lot of SMEs who've got a Chinese partner and they'd say, don't worry, we'll take care of the trademark, and have registered in their own name. Now, whether it's due to fraud or misunderstanding, I don't know, but always take care of it yourself.
Good practical point. And then there's another point about practical matters here. How do you gather evidence? So evidence for infringement claims, how do you do trap purchases? Do you have to notarize those? Evidence for the extent of infringement for damages? I mean, Adam, maybe you could comment on that. Do you have any thoughts?
It's exactly as you've described, that yeah, we get we've had to make trap purchases and then get those notarized, and we've ended up with a situation where you make the you make the trap purchase, and the goods are sent out to you, and then having to be photographed at every stage, and then sent back to China to be so they come out of come out of China over to you or your distributor, and with having to make sure that it's not the package isn't interfered with at any point, and then sent back to China again to be notarized and legalized. But yeah, it's a hassle, but it's yeah, easily enough done.
And Lindesay, did you have any further thoughts on those evidence gathering points?
Yes, I mean, I think this is where administrative action is really helpful because, for example, if you are going to purchase direct from the infringer, you can't really bring a notary to their plant and say, buy some bottles. So by getting the authorities to raid first, that's an excellent way of gathering reliable evidence, which you can then use in subsequent court proceedings.
Thank you. There's a question here that's probably best addressed to Claudia. Is applying a mark in China to goods which are for export only considered to be use of the mark in China? And is such use considered to be infringement of the Chinese registration?
This is really good question, I would say, because I think the Chinese government, especially the Chinese courts, are, swinging from one side to the other in the past 10 years. I think that when I just entered into this industry in 2004 or 2005, the same year when Lindesay started his battle in China against the infringers, I think we had a very typical case where there's a manufacturer in China producing Nike products and export them to Spain for a seller in Spain who have registered the Nike trademark in Spain, while Nike had its registration in China. And in that case, Nike was successfully able to convince the Chinese court to make a favorable decision for them and say that the manufacturing itself for the Nike products will be considered as infringing, even though all those products are being exported outside of China. That kind of activities will be considered as infringing. So in that case, that was the very typical one that were held as manufacturing something in China, bearing the trademark being registered in China, and that kind of activity may be considered as infringing, even though the products will be sold in foreign jurisdictions. But then after a few years, I think the Supreme People's Court changed their attitude, and they started to think that if the products are not being sold in the Chinese market, then there should not be any confusions in the market. So that kind of activities will not be considered as infringing at all. So in some Supreme People's Court cases and in some other cases involving the pure manufacturing activities in China, they were held as non-infringing. But in recent years, I think the attitude is changing. More courts would hold that manufacturing activity itself would be considered as using the trademark on the products, and that kind of activities, no matter whether the products at the end of the day would be sold in the Chinese market and whether the Chinese consumers would be confused about the source of goods, that kind of manufacturing activities would be considered as infringement. So I think the Chinese courts are weighing from one side to the other in the past over 10 years. But I think the core is that we need to make sure that when someone is, or when our Chinese manufacturers, when they are doing their business, they will have to check on the trademark, and they have the liability to check whether the trademarks that they are using on the products, whether they are being registered, whether they have the license from the trademark owner to grant their license to do the manufacturing. This is something that Chinese manufacturer will have to check. And we have regulations saying that Chinese manufacturers would have this kind of liability of checking the origin of the trademark. And this is one thing. And the other, we need to take a look at the foreign registration as well. For example, if in some cases, if the trademark is being registered in some foreign jurisdictions, then those foreign parties, they entrust the Chinese party to do the registration for the products being shipped to that particular foreign jurisdiction. Then in some cases, maybe the court would think that this type of activity would just be a kind of authorization granted by the authentic and genuine trademark owner of that foreign entity. And that kind of activity, some of the judges will think that kind of things, that kind of activity will not be considered as infringing. So
thanks, Claudia. I'm sorry, I think we're going to have to wrap up now, but thank you so much. I'm really sorry, everyone, that we haven't done all of your questions, but given the time, I'll hand back to Mark. Thank you.
Yeah.
Fantastic. Thanks, Isabel. And thank you to all of our panelists for what I think has been a really informative and insightful discussion of some of the issues. And there are so many around IP protection enforcement in China. Really interesting to hear such diverse industries and their approaches to it. Thank you, Claire, for putting that together and chairing the session. And thank you to everybody for the questions. As Isabel says, more questions than we had time to get around to, which suggests it's been interesting for you out there as well. And actually how delightful to see that people feel more encouraged about enforcing IP in China than they did at the beginning of the session. If you have any questions about any of the topics raised, our contact details are on the materials which come out in the follow-up. This is the last of our Talking IP sessions before we take a short break for the summer holidays. We'll be back in the autumn, back in September. So look out for emails with details of the next Talking IP after the summer holidays. Have a great summer holiday, those of you who are getting out somewhere. Thank you very much for attending, and we will see you soon. Thank you.